But our last speaker for today is Nina Kaiser. Nina is an admitted attorney and a tax partner at Weber Wenzel, attorneys in charge of tax dispute resolution. Her areas of expertise include representing clients in a broad spectrum of tax disputes with the South African Revenue Service, assisting clients under audit or investigation by SARS. And prior to joining Weber Wenzel in 2004, Nina was employed as a legal advisor at SARS for 8 years, so she's seen both sides of the fence, if you like. And her main tasks at SARS were to resolve disputes between SARS and taxpayers and to provide legal and tax advice to SARS audit teams. Her other duties included providing legal advice to the criminal investigation section, civil litigation between SARS and taxpayers, and prosecution of tax evaders. Nina will be talking to us today on the SARS recovery powers and the Tax Administration Act, which I think, given her background, she's well qualified to do. Thanks, Nina.
I want to thank the organisers for giving me the opportunity of doing the graveyard shift. Glad to be here. I need a click thingy.
Is it not there?
IT?
It's there. Yeah.
Is it there?
There you go. Next to the mic. There you go.
Thanks. Okay, so I know that you had an overview of the Tax Administration Act yesterday, and I wasn't here, so I hope I don't repeat too much. My instructions were to prepare a presentation on SARS's new recovery powers, and some of them are not so new. I don't know what people are getting so upset about. You know, things have been in the Act since 1980 something. You know, when the Tax Administration Act came out, they're like, look at this, they can appoint someone to collect tax. So they've been appointing banks as agents for years. Why are you upset? But anyway, I will try to explain the difference between the old and the new provisions, and hopefully I can give you some insights or share some insights practically on things that you could be arguing of how to get out of these recovery powers that SARS has. If you're looking at your Tax Administration Act, the recovery powers are generally contained in Chapter 10 and 11, and they deal with the liability of representative taxpayers, withholding agents, third parties, which is sort of a new concept. SARS's right to extend, to ask for security, which has been extended from the VAT Act, and this new thing, which is the preservation order. And then Chapter 11 expands on those rights with respects to responsible third parties, and it also has some new tweaks to the civil judgment provision, and there's this new thing about compulsory repatriation of assets. If you're so lucky to have something overseas, you know, SARS can ask you to bring it back so that you can pay your tax, you know, like Dave King and the like. I don't have anything overseas, Katanka, just in case you're wondering. Right, okay. Right, so that's what I'll be dealing with. Somebody must just stop me, you know, when it's time to go. Somebody must in the audience, if you just say, we've had enough, we've lost the will to live, I will stop. Right. Okay, so the first thing is dealing with representative taxpayers. They are generally the public officer of the company, and the public officer is also supposed to be the representative vendor for VAT purposes, and the public officer is also supposed to be the representative employer for PAYE. And this unfortunate individual, who must be a natural person and who must be a senior official of a company, has the unfortunate position of being responsible for everything that a taxpayer, which is a company, is responsible for under a tax act. So if a company, which is basically a piece of paper that's filed somewhere at CIPRO, has to submit a tax return, SARS looks to the public officer. So essentially, nobody wants to be the public officer. If you ask, will you be the public officer? Just say no. You know, it's just too much trouble. So the unlucky person who didn't see what the requirements are and the obligations are, who said yes, this person is responsible for ensuring that the company complies with its obligations under the Tax Act, including the obligation to make sure that the company is paying the taxes when it is due. Now, the interesting thing with regards to the way that the liability of the representative taxpayer is worded when it comes to the payment of tax. So to what extent in your representative capacity are you liable to pay the tax of the company? It is actually, strangely enough, sort of limited. So if you look at the orange section, it's only in respect of income or money to which the representative public officer is entitled, money under his management or control, transactions concluded by this person, or anything else done by this person. So what I'm trying to say to you is, if you are the public officer of a company, A, resign. If you cannot resign or they will not accept your resignation, make sure that you are not entitled to receive any money on behalf of this company, because then you can't be held liable. Make sure that you do not manage or control any money. Make somebody else the signatory of the bank accounts, because if it's you, you have a problem. But if it's not you, not your problem. Transactions concluded by you. Do not enter into transactions on behalf of the company which could have a VAT effect or a PAY even. Let somebody else do it. In fact, pretty much do as little as you can, and your liability as a representative taxpayer will be limited. Right, I'm sure that that is not what was intended, but that is what it says. So we're going with that. The next thing is, you can also be held liable in your personal capacity, and one of the reasons why people didn't want to be the public officer, and they tried to appoint the secretary, or I don't know, their accountant or the bookkeeper or whatever as the public officer, is that you have personal liability. The nice thing is that your liability, your personal liability, is limited to what your representative capacity or your representative liability would have been. So if you're not in charge of any of the money and can't enter into transactions on behalf of the company, your personal liability is also zero. Right, so try to do that. But if for whatever reason you alienate, charge, or dispose of the amount in respect of which the tax is chargeable. So let's say you're now suddenly in charge of paying bonuses and you hand out bonus checks, maar ons het niks PAYE afgetrek nie. That would be bad. Do not do that, because you could then be held personally liable. You handed out those checks, right? The second thing is, if you dispose of money out of which tax could legally have been paid for the company. This has always been in the Act, nothing to get excited about. If there is money, you can use that money to pay tax. The tax must be paid. So do not dispose of it. If it needs to be disposed of, let somebody else dispose of it, not the public officer, right? Okay. Right, so that's representative taxpayers, done and dusted. It's not so bad if you think about it. Withholding agents. Withholding agents are sort of a new category. It's defined as anybody who must withhold tax. So I have checked the Act, and I think it's dividends tax, PAYE, withholding tax on royalties, the withholding tax on interest and management fees one day when it ever comes into operation. Here it's now 2014, maybe it will be extended again, but that's coming. But once you are that person who has to withhold, you will be a withholding agent. And then if you're selling a property to a non-resident, or buying a property from a non-resident, essentially there's a withholding obligation. So those are the examples that I could think of. There might be one or two that I missed. I don't think that if you're a VAT vendor, you're a withholding agent, because you don't withhold VAT from a payment that you make. You just receive it, and you claim the input tax back. So I don't think that falls into this category. The interesting thing is, if you should have withheld tax, so you thought, well, there's a treaty, I'm paying a royalty, it's probably exempt under the treaty, I'm not going to withhold this withholding tax on royalties. And SARS says, we didn't read the treaty properly, it's not a royalty as defined under the treaty, for example. That can happen, it has happened. Then the person who paid the royalty is suddenly personally liable. In other words, you have to pay this tax now to SARS, even though you already paid all the money to the other person. So that is a personal liability. The interesting thing about this is that when the withholding agent, who basically forgot to, or on a wrong interpretation failed to, or just didn't feel like it, or was bullied by the party on the other side, if you didn't withhold and you now go and pay it over to SARS because they raise an assessment on you, then you're deemed to have paid that person's tax. And that is also, it's not a tax that's payable by you, even though you're personally liable for it, it's deemed to be the withholding tax for that person paid. So if it's a dividends tax for a shareholder, then it is the shareholder's dividends tax that was paid. But not for PAYE, even though it doesn't say so in the Tax Administration Act. If you go back to the 4th schedule of the Income Tax Act, is if you screwed up your PAYE for some reason and you didn't withhold the right amount, and SARS gives you an assessment, and you pay that money without recovering it from the employees, the Income Tax Act says that's a penalty. So then it's not deemed to be a tax paid on behalf of the employee. So I think this is the only example that I can think of where this wouldn't be true. Although the two provisions are conflicting, or they appear to be conflicting, the specific provision would override a general provision, and the specific provision is the one that deals with the PAYE. Okay, so that is withholding agents. Now we get to a very interesting category of responsible third parties. Now, they are not representative taxpayers, like it's not the public officer and it's not these withholding agents. These are other people in the Tax Administration Act. They are agents, we know them as agents. The old provision was SARS can appoint you as an agent to collect tax, and usually it was an employer or a bank. They're now appointed third parties because it's apparently less confusing. The financial managers of a taxpayer, that could be directors or CFOs, whatever, shareholders. Persons to whom assets are transferred, and persons assisting with dissipation of assets. So I will deal with these categories, but the important point I want to make on this slide is this specific group of taxpayers who are responsible third parties. SARS has the same powers of recovery against them or against their assets as they would have against the taxpayer. So, if you are a responsible third party, SARS doesn't have to go to court and make a declaratory order that you should have not disparted with this money or whatever the case may be. They can take judgment against you. They can send the sheriff out and then sell your assets. So they can do anything to you as the responsible third party that they could have done to the taxpayer. So there is no funny court application, because previously there was a bit of a debate as to how would you hold someone like this liable? Would you have to raise an assessment against them? And then in that case, what would the assessment be? Who would be the taxpayer? Or would you have to go to court and get an order that this person is now liable? How will it work? Well, now it's apparently quite clear. SARS can just take the money from the responsible third party in the same way that they could take it from the taxpayer. Okay. Now, the first category that I want to talk about is the appointed third parties. Now, there has always been a provision in the Act that says SARS can appoint someone who's holding money on behalf of somebody else as their agent to collect. So it's like an involuntary mandate that is forced on you to collect money on behalf of the state. It's always been there. Generally, banks are the unlucky recipients of these notices, and employers frequently. If SARS is really digging into a matter and it's really hard collections, they might go through your financial statements and try to attach your debtors. In which case you generally say, well, thank heavens for that. You know, nobody could get money out of those people anyway, so let SARS try. But anyway, I've even had a client who said, I'm offering my debtors. Can't they just appoint these debtors? SARS declined. I don't know why. I did offer. The thing under the old provision is you had to have had money to be able to be appointed, or you had to have owed money at the time that you were appointed. So if I'm a bank and the taxpayer's account is an overdraft, I'm not holding money on behalf of this person. So if SARS appoints me, I'm saying, well, sorry, you can't appoint me as an agent. I'm not one of the kind of people that you can appoint because this person doesn't have, I'm not holding money, he doesn't have money in his bank account, and SARS would have to accept that. The problem is this act now says it's somebody who holds or owes or somebody who will hold or will owe. And this is where I have a pretty much question. Let's take a bank because it's a practical example. It happens every day. You have an account that is in overdraft. It's been in overdraft for years. The bank has been stringing you along. But now comes SARS and says, I want to appoint you as an agent because at some point this person might actually pay back his overdraft. His account may go into the positive for the first time in 10 years, and then you will have money. So at that point, which may be a long time in the future, and you may have, 20, 30,000 account holders. I don't care. I want the money from you then. Now that I question. Because how is it for SARS to say this person, I could hold money on behalf of any of you at some point, Or the only thing where I think this makes sense is for an employer. Because an employer will pay his employee the next month. So SARS would have to apply their mind to this future obligation to pay money to the taxpayer and trying to appoint them now in case in the future you have to pay money to the taxpayer, then you have to give it to us. So this future having to will hold thing makes me just uncomfortable, and I think there are limited circumstances where SARS could apply that. Now, a new thing about this notice is that the notice, you must get a notice and you must get a period within you must comply. So you have employees, and SARS will then presumably say, dear Weber Wenzel, Nina Kaiser owes us a lot of money. Please dock her pay for the next 6 months until her tax has been recovered. I hope that doesn't happen. Anyway, so there could be, Weber Wenzel could look at this and say, well, gosh, this is a lot of money. She's not going to earn this much money from us in the next 6 months. This is a problem. Now, what the provision now provides for is that you, as the person who's being appointed, can go back to SARS and give reasons why this is not going to be feasible. Previously, it wasn't possible. Previously, it was simple. Either you had money and you had to pay it over at that time, or you didn't. Einde van die story, but not anymore. Now it's a question of if you don't think it's feasible within the period. I don't know if those notices now contain periods within which you must comply. Do they? So you must pay within a month, you must pay within 6 months. Then you can actually go back and say, I'm sorry, for these reasons this is not going to work. For the first time also, the taxpayer, the poor taxpayer whose bank account is being depleted or whose salary is being docked can also now have something to say about this. This wasn't previously in the Act. Previously, what happened is the company's bank account was drained. The people would come to me and say, yes, we actually do owe SARS money, but they took all of our money out of the account and we have to pay our salaries tomorrow. And the answer to that would generally be, if you owe SARS money and they got it, they're not going to refund it to you. So the new provision says, well, the person who's affected can give reasons why this, why you shouldn't be withholding. Like, I have to pay all of my employees tomorrow. You can't take all of my money now. That would be a good reason. Or you have to pay your own basic living expenses. Like if somebody's taking your entire salary away, how do you actually then pay your bond, buy food, petrol, the basic things that we all need to live? So presumably, my employer would come to me and say, well, SARS wants to dock your entire pay, then I would have to actually work out a little thing to say, well, these are my basic living expenses. Hopefully they're reasonable. These are my dependents. I have to pay their living expenses to, please just deduct the balance. So there is some kind of a process which did not exist previously. And I think this also opens the door for the person who's being appointed, like the bank or the employer, to go to the taxpayer in question and say, I've been appointed, I can't give you the money right now, otherwise there's a risk of personal liability here, but do you have basic living expenses or whatever that you won't be able to pay? We need to talk to SARS. So it seems that there's a little bit more room to maneuver with this one, which is actually quite good. The only thing that I don't like about this is this thing that you might in the future, SARS official, senior SARS official looking in the crystal ball, it's like, oh, you will have money on behalf of this person. I don't like that one, but the rest I think is pretty sensible. Financial management, yes.
Without checking. Hi. Assuming the agent deducts the money without checking with the taxpayer, can the taxpayer sue or demand the agent to repay them that money?
Yes, you see, what if the agent wasn't validly appointed? Or there was some defect in the notice, which I haven't thought about. Look, I think if the agent doesn't have an obligation to check. That's not in Section 180. The Tax Administration Act, and I forget the exact provision now, says whatever assessment or statement made by a SARS official that this is the tax that is due prima facie proof, until somebody proves differently. That is true. But there could be a situation, and I'm dealing with a case sort of like that at the moment, where I have submitted this application to suspend the obligation to pay pending an objection. But there is an assessment due, and I've asked for it in terms of Section 164. Somebody talked about that earlier today. Now, if you read Section 164, it says SARS may not do anything from the time that they receive that application until 10 business days after they've denied it, or if they've given it, it's been withdrawn. So SARS is not allowed to do anything to collect that tax because they are supposedly considering, I don't know what happens to those applications, it goes into a black hole somewhere, but somebody hopefully at some point will apply their mind and look at it and consider my very solid application for suspending the obligation to pay a tax debt. Now, SARS is not allowed to appoint someone as an agent at this point. So if SARS now goes and appoints someone as an agent, and that appointed agent pays that amount, they've paid in terms of an invalid appointment. And there is some liability issues here. So the answer is, and I mean, we're in sort of new territory here, is what do you do? If you know you've made an application to defer, let's go to Weber Wenzel and my big tax. By the way, I don't owe any tax, just SARS people, just don't get, if you, just checking. So, but in my example where I owe a huge amount of tax, if I now go to Weber Wenzel and say, look, I've received this ridiculous assessment from SARS. They've assessed me for understatement penalties going back to 2000 and I don't know what. It's all ridiculous and unconstitutional. I've objected. I've applied to have that tax debt suspended until my objection is heard. They've either granted it or they're still considering they're not allowed to recover this, so do you not dare dock my pay in the meantime. Then I think if Weber Wenzel goes like, let's just pay it over, then I might have a claim against them. I would think. But this is new territory, so it's new things that we're trying out. So, no idea. But with no idea whether that will actually work, but your claim against the appointed agent is not a claim that's lying in the Tax Administration Act. Your claim against that agent is in common law. So there's no statutory magical stick that you can wave and say, this is what you need to do. Now SARS is not, no, she's
Hello, Nina.
Yes.
I'm sorry you don't have assets overseas because it means you're not doing that well. But in any event, I'm not in enforcement. It's actually a valid point because what we did in Section 160 sub 2 is where a withholding agent is obliged to pay money to SARS, he is protected from any recovery right by the taxpayer on whose behalf the money was withheld. The principle being that if you're compelled by law to pay, there's no, right of recovery against you. But one should perhaps revisit 162 because an agent obliged to pay under 179, now called the responsible third party, is also compelled by law to pay, and there should not be any right of recovery against that agent. So one could look at that, but in any event, I think there is a common law principle to that effect. If you're obliged by law to do something, there's no recovery. Thanks.
Thanks, Dr. Cole.
Nina, 179 says a senior SARS official may, by notice, appoint somebody. Now, my understanding is that financial institutions get appointments electronically with a spreadsheet at the back. And on the document, nowhere is there even the wording senior SARS official. So what are your views regarding the validity of that appointment? Because, first of all, if the bank pays over and the clients come back and say you were not validly appointed, therefore you've got a liability, because the documentation quite clearly, the context of the provision is that a senior SARS official should apply his mind regarding, because it's quite a severe intervention. Now, if this is merely a computer-generated document, would you regard that as a valid appointment?
Right. So the computer is not a senior SARS official. I think you're right. Look.
Yes, we just don't know
Right, okay. Although there is a minor debate going on as to whether the computer is a senior SARS official or not, I think Johan's point is valid, is that this appointment, surely the agent that is being appointed, whether it be by a computer or not, has at least the obligation to consider whether this appointment is valid or not. And if this employer or financial institution receives appointment, or we still refer to it as agent appointments, if you receive the agent appointment, you probably have the obligation to check, well, is this an actual valid appointment? It could be a 419 scam for all you know, but I got two this morning. I got a refund from SARS, yay, but then I saw the address was www.sars.co.za, okay, so I think there is at least an obligation on the person who's being appointed, because you've got the duty of care. Presumably, under common law, you are holding somebody else's money, so you have an obligation, like, look, I'm holding your money. If somebody else, a third party, intervenes and says, you have to give that money to me, I have to at least wonder, is this a valid appointment? But I'm assuming, and maybe there are members of the audience who could maybe help me, but that the system for the appointing of the banks, and there is a very knowledgeable person sitting right there, if you can get a mic to her, that the person behind the appointment of the bank as an agent is a senior SARS official. I don't know whether that is checked, but I'm assuming that there's a procedure that has been agreed between SARS and big financial institutions as to how this would work, and that there was a senior SARS official behind that. But maybe if we could get a mic here to Marlene.
Sorry, Nina, just before that, I understand your point, but just to think about it on a practical notice, would it not be too onerous on financial institutions as well as employers who are receiving 1,000 of these a month to sit and validate every single one of those notices? And in your instance, for example, where you said the 10 days, to check that the 10 days have expired or the extension has been withdrawn before then they go back and actually action it from a SARS perspective. So I think it would be too onerous of a duty on financial institutions to go and...
I think there are some financial institutions who would definitely agree with you on that point, because they're probably inundated, but maybe Marlies can enlighten us.
Although on employers you get this, can I call it Excel spreadsheet on EasyFile, you can actually go into EasyFile and print a copy of the regional official notice. Okay. So you have that, and I can just mention that for, I think, the last 5 years, we have fought with SARS on the, and I'm talking employer now, because an employer cannot determine affordability. Under labour law, you've got no right to ask a person what their expenses are, and you actually just don't do that. And with a number of agent appointments that employers get lately, you also don't have the capacity to do it.
Yeah.
So at last, SARS has changed because the Act said they've got to determine whether you can pay your basic living expenses. Now, I think last weekend, and I haven't checked if they have rolled it out, within the last 2 weeks, they've rolled out a new EasyFile agent appointment system where you can actually, if the person has enough money, you can pay immediately.
On EasyFile, somewhere.
Yeah, on EasyFile. Then there's a button that the person cannot afford it, and then there's a drop-down menu that tells you if this is the amount due, then you can pay it over 2 months or 3 months or whatever the case is. And then there's a third button where you actually print a letter to the and give it to the employee so that they go to their branch office to request an affordability test.
So this last bullet
But the
that we have.
employers cannot do that. There's nothing under law that you can request that information, and not even in terms of the Tax Administration Act can you do the determine affordability.
Yeah. I think that's about it. So there's two things that I take from this. The one is that the system is fairly automated, that it's all on EasyFile. So Johan's point might still be relevant, isn't there, that some not so senior SARS official, loading up this information onto EasyFile, this is the money that we want to collect. So that is a valid point. What I don't know the immediate answer to is there an obligation on you as the employer to then go and determine whether that was. But if you can print the notice off EasyFile, then surely the person who issued the notice must identify him or herself as a senior SARS official. The commissioner. Well, I'm assuming he's senior-ish. So let's assume the commissioner is senior. So it seems that the system is quite automated, and also that the right that you have to request, that you need to pay your basic living expenses, which is the person affected, not the employer who has to ask for it, that the employee then can get this letter and complete it and say, well, these are my basic living expenses. Yes.
Sorry, Nina. Just to add to what this lady said and what you just confirmed, if that letter goes out to the employer, it gives the employer or you as the taxpayer or the employee a chance to give them your living expenses so that they can determine your affordability. But just before year end or closing of the financial year, SARS sent out all these
no, but you can't
debit
take
orders.
anything that SARS does in March seriously. Really, those people are rabid dogs.
They sent the instruction to the bank immediately, obviously knowing that there's not that close contact maybe.
Yeah.
They didn't leave that door open for the client, for the affordability. What they did with the clients was to clear the whole bank account, including what was left over. That client they were in the positive, they weren't in a negative. So that's what you were saying, in future. So they cleared the whole, the cleared account plus the overdraft, leaving the clients with a problem because
that is
they were
ridiculous.
not able
Are you
to settle
telling me
their
they
debts.
forced people to go into overdraft? So they're forcing the bank to lend money to taxpayers to enter an agreement to
We
pay
had
tax.
several.
I mean, that definitely is actionable. I think that is not only administratively unfair, it's outside of the scope of the provision.
And it's unlawful.
And it's unlawful. And I would assume on that basis that is administrative action that is not even valid.
Yeah.
So
We had several of those
So that is egregious, and but as I say, anything that SARS does in March, you have to take with like a ton of salt, because they're all very mad to meet their budget or something. Yes.
The bank cannot pay anything over that takes you into overdraft. The law is very clear. It's monies,
Yes.
money that must be held by.
Yeah,
And an overdraft is not held by, it's a credit facility.
yes, I would agree.
In a case like that, I hope it's not our bank, but in a case like that, I think you can take action against the bank.
Yes,
If they
I'm
take your
sure if you
overdraft.
suddenly get this, your bank statement, you think you've got money and you see that you've maxed out every credit facility that you have. I mean, is that even, I suppose if you were in the National Credit Act, there's all kinds of things that comes into play in this kind of situation. I think that if SARS goes to a bank and says, well, you must give us this money and we want more than you're actually holding, on the basis that you will hold in the future, I would take them on that because they can't know. This person could close the bank account and that's probably what they do. I mean, most people would say if somebody comes to you and they've got a big problem, it's like, gosh, I hope you've got another bank account. Because except for the one that's on SARS' website, you know, on the get another one because there's a big risk for you here. I mean, is
Nina,
that subject to legal privilege? Yeah, thank you. Okay. Right.
just to add to your woes, a bank was last week
add to my woes. How are you on?
forced to actually liquidate a fixed deposit, and
Pay the
monies
penalty.
had to be paid across. So early termination, penalty to be deducted from the proceeds and balance to be paid over. So this is what happens.
You see, the fixed deposit, the problem with the fixed deposit is you usually have enormous penalties. So SARS is also just, they're costing you money. But I suppose SARS's argument would be that it is money held on behalf of someone. So even though it might be horrible, that all this interest that you're going to lose and whatnot, technically you are then holding money on behalf of a taxpayer, and the law says you can be appointed, and it has always been like that. It's not new to the Tax Administration Act. I think this eking into somebody's overdraft, that is not even legal. But from what you're saying, I've got sympathy for the situation, but I don't think that SARS is acting outside of the scope of their duties if they ask you to liquidate a fixed deposit. And why should you be having a fixed deposit while SARS is losing interest? That's probably what Katinka's going to tell me now. Yeah.
Just wanted to ask you one, was that also during year end? Because as far as I know, there is a policy that fixed accounts
don't pay.
pursuant to the bank's law. I mean, the argument is that statute overrides contractual. So if the fixed deposit is only contractual, arguably the statute requirement could override it. But as I understand, there's a Banking Act obligation on the banks not to do that before the expiry of the period. In other words, you have statute versus statute. So this was actually quite news to me that this happens, but hopefully it will be addressed.
That's quite useful to know. Thank you. Yeah. Okay, so Banks Act. Okay, so the Banks Act experts have now enlightened us. I'm learning more than you're learning, I think. Is that in terms of the Banks Act, you're not allowed to touch the fixed deposit until such time as presumably the account holder tells you you can do so. So you've got one act conflicting with another one. Not always. Not always. Right. So if you have money, put it in a fixed deposit. Okay. That's the lessons learned here today, people. We've learned do not touch anything when you're the public officer and put your money in a fixed deposit. Okay. And have another bank account that SARS doesn't know about.
There's nothing that prevents SARS from asking you what the maturity date is.
Yeah.
And then issue an AA88 on that date.
Yeah. So they'll get there first. So they'll say, when does this come out? And then, but hopefully by then they would have lost interest and moved on to somebody else. No, apparently not. Right, so that, thank you. Financial management, this is a big relief that this provision has been changed. Previously, I've given a couple of opinions where the director of a company comes and says, I'm the director, the company owes either PAYE or VAT. Am I personally liable for this now? Can't we just liquidate the company? And then you have to say, no, you're a director, you're in charge of the money of the company, it is VAT, you're liable. And it was quite a scary provision. The worst I've seen SARS actually do in practice that I've been involved with is that, particularly where you're dealing with people who are closing down their businesses, is that SARS has asked me to give reasons why they shouldn't hold the director personally liable for VAT or PAYE. But it is a huge risk, and the way that the old provision was worded is if the company cannot pay, it doesn't say unless it is liquidated, it says if a company cannot pay, the director is personally liable for the VAT or the PAYE. Now, thank heavens, it's broader, but it's better now, I would say. Firstly, it's any taxpayer, not just a company now. So I would assume that you are a trustee of monies of a trust, then this could also be an issue for you. But the good thing is that negligence or fraud is actually required. So it's almost like that old company law provisions where if you're a director and you're negligent or you act fraudulently, then you're personally liable for the debts of the company. You now have this new requirement for negligence or fraud. But even if you were the biggest crook under the sun, or you were completely negligent and had no systems in place, the negligence or the fraud needs to be causally connected to the non-payment of the tax. And some SARS official has to apply his or her mind and say, I've looked at this and this is definitely, this fraud was you purposefully did something or failed to do something which had something to do with the non-payment of our tax. Now, the one thing that is a bit tricky here is if you are responsible for the overall financial management of a company and you are the financial director, then surely if you know we've got money coming in, we've got a huge tax debt, we're not going to pay it, you are sort of negligent, aren't you? You know, would a reasonable person not have then ensured that the legal or the legally due money would be paid to SARS? So maybe a little bit easy for SARS, but I would argue that if you're not the person, even though you're in charge financially overall, if you're not the person who's literally in charge of making or ensuring that tax is paid on time in that entity, you could probably argue that you're not liable. So I think this is better. And because there's this link of negligence or fraud, I think it might even pass constitutional muster. So this one, this is definitely an improvement on the old provision. Whether it is retrospective, I would have to ask my colleague now. It relates to an action that took place before 1 October 2012, which was incidentally the anniversary of CGT. It also came on 1 October. I don't know what goes on at 1 October. Anyway, so if it happened before, so it was a negligence and it was fraudulent and all of those good things, but it happened before 1 October 2012, then essentially you would have an argument, well, look, this was an obligation, so I don't know what your view is on whether this would actually apply retrospectively. Yeah.
I certainly think there's argument
that it could apply. So even if you're not the director anymore, it could still be a problem. Okay, so shareholders, this is also massive improvement. Previously, as with directors, if you were a shareholder of a company, any company, and you were involved in the overall financial management of that company, and that company was unable to pay its tax, you would be personally liable. Now, everybody can sigh of relief. It's only when the company is wound up. Okay, so you don't have to worry about this until the company goes into liquidation. So shareholders can no longer be held liable for the VAT of the company if it goes into involuntary liquidation and there's no money left to pay SARS. That's fine, the shareholders are not liable. this only applies really to involuntary. I can think of, you can deregister a company, or the directors can decide, the directors and the members can decide, we're going to wind up this company on an involuntary liquidation basis. If you do that, then you have to ask the question, did our shareholders in the last year receive any money in their capacity as shareholders? So did we make any dividends in specie, cash dividends, capital distributions in the last year to our shareholders? Because if you did, and you're doing a voluntary liquidation, so you may think, we're done with this company, it's lived out its purpose, let's wind it up. We pay out dividends to all our shareholders and forget about it. And then SARS comes along and says, well, okay, you guys, actually, if you did your taxes properly, you would have realized you owe us X amount of tax. Then they can take it from the shareholders. So it is an improvement because SARS's right to go back is more limited, and it's clearer that when would the shareholders actually be liable. Right. The interesting thing about this, and then maybe if Katinka over there could just speak to the drafters, this liability is, well, she's got pull, I don't. Okay. So this liability is jointly and severally, which means that if the one pays, the other one is excused, whatever. But it's also secondary to the liability of the company. So I don't know how something can be secondary to and joint and several at the same time, but that is how the Act is drafted at the moment. So I suppose SARS would say it's joint and several, because I want the money from the shareholder, and the shareholder would say, no, but you must first try and get the money from the company. But I think that's maybe just a drafting error that slipped in. And then also, just because you got in 1998 50 Sanlam shares, you don't have to worry about it. Listed companies are excluded. Okay, so that's not a problem. Okay, transferees. This is something that was borrowed from the Insolvency Act. It's similar to a disposition without value. In the Insolvency Act, if a company goes into liquidation and you find out that right before the company went into liquidation, the company disposed of all of its assets to another company, coincidentally held by very similar shareholders to the one that we're dealing with, and we sold our assets and our business for next to nothing. That would be a disposition without value, and you would be able to, under the Insolvency Act, claw back those assets into the insolvent company for the benefit of the creditors. Now, this is sort of similar. Here you have a situation where you have somebody who's a connected person in relation to a taxpayer. That is a very broad definition. Everybody, we're all basically connected. If you read that new interpretation note on connected parties, it's quite broad. You have to be careful who you marry, because you might just create a whole new string of connected parties in relation to each other. You think I'm joking, read that interpretation note. So the thing is, you must be a connected person in relation to the taxpayer, and you must have received an asset from the taxpayer, either for no consideration or for consideration below market value, and it must be within 1 year from SARS's notice. So if SARS, in a situation like that, doesn't have to put a company into liquidation, SARS can simply go and say, I'm not going to put you into liquidation and then try and apply Section 26 of the Insolvency Act. Within the last year, you have disposed all of your assets to this other company to avoid your obligation. We don't even have to say that it was to avoid your obligation to pay tax, you just did it. Then SARS can claw that back from the transferee. So then suddenly the transferee is liable. The liability of the transferee is limited. So it's only to really the loss that SARS suffered in this situation. Okay. This responsible third parties who assisted with dissipation of assets. This is similar to the collusion provisions under the Insolvency Act. It is really where somebody was like, outright being scallum. You knowingly assist someone to obstruct the collection of tax by helping that person to dispose of assets or reduce assets. So that is just sort of collusive behavior almost. And in such a case, SARS can go to the person who assisted. But now I'm just thinking, to what extent you must knowingly assist? So I know that you owe tax. You have a farm, she wants a farm. You can sell it to her and then maybe later she can pay you under the table. I arrange the deal. I'm assisting you, but I'm not benefiting. I want commission. So, but I mean, potentially I'm liable, okay, for this, for the whole value of that you saved. Right, so hopefully it doesn't happen. Okay, I'm almost done. Have you lost the will to live? You're all right, okay. Security. I always found the security provisions in the VAT Act very strange because, and I don't think SARS used it that often, but I tried to use it when I was at SARS, but it was always a kind of bizarre situation because to have to ask for security, you're generally sitting with a company that's already been lax in complying with its tax obligations, so generally they would owe the receiver a lot of money. So you would think this is a good time to ask for security, and under the VAT Act you were allowed to do that. And the problem is if you ask for a cash payment as security, it's like, yeah, we can give you a cash like to be held somewhere, then you think, well, you owe the money, the tax debt is running interest, why don't you just pay that, you know? So it always seemed to me to be a bit of a strange provision to ask a cash amount as security because the taxpayer hasn't been paying his tax, you know? So why not just pay it, because you're going to incur an interest liability. But anyway, it's to safeguard the collection of tax, whatever that may be. But it can only be if you are in one of these categories of taxpayers who have become personally liable for somebody else's debt, ironically. If you've been convicted of a tax offense, you frequently fail to pay your taxes due, etc. Now, the one thing that does concern me is if you already have money due, then you've presumably traded, a profit has been determined, or a VAT payable has been determined. The money is due. SARS knows that they have to collect this money, and SARS knows that they must safeguard the collection of this amount of tax. But how will SARS know that in the future I will have a tax liability? How will they determine how much that's going to be? Are they once again senior SARS official with a crystal ball is going to go, this company is going to make huge profit next year. That's what's going to happen. They are a problem taxpayer. I want security for this money that they're going to earn in the future, which will be a problem to collect from them, because that's essentially what it says. So I think that is maybe taking it is what it says. I think somebody with a deep pocket, you know, come talk to me, we can take them on, we'll get counsel, we'll get all kinds of advisors here. I think that might be quite an infringement on your right to property. I don't know, I have to ask some of my learned colleagues here. But also, SARS can say, we want surety from your shareholders. If so, let's say SARS comes with this notion, it's like, I think you're going to make money in the future, it's going to be a problem to collect it from you because you've been convicted of a tax offense. I want R1 million as a cash deposit to keep safe and apply towards your future tax liability. I said, but the company doesn't have R1 million because this profit is notional, it's airy-fairy, it's going to happen in a year from now. So then SARS can say, it seems to me you cannot do this. Therefore, I now want surety from your members and shareholders and trustees that they will now personally stand surety and be personally liable for the company's tax debt. That is a bit harsh. But anyway, and the other thing that could also, this is the scope for abuse with this provision, because let's say you have a VAT refund due because you are an exporting company, and SARS says, well, you have previously not complied. We're not paying out this particular, I'm not giving the SARS officials any ideas, we're not going to pay out this refund to you because we're holding on to it as security for your future non-compliance. And there they have it, at no interest, no nothing. So this one, I haven't seen someone try to apply it now in practice, but it could be, I mean, there's scope for abuse here, and we don't really know how it's going to pan out. So there and there, yeah.
That's right.
Thank you. In practice, we are in a similar situation. We have a client who's having a refund due to him, huge refund, VAT refund, which is more than what he owes or what the company owes. And we applied because there's also an objection in that assessment. So we applied for Section 164, suspension of payment because of the cash flow problems. And SARS says,
give me a security. And we're like, there's a refund which is due to us, which is sitting with you, and a huge refund which is more than what the client is owing. And we're told the collectors are speaking in their own room, and the auditors who are busy with the audit of the refund, very slow and nicely. So we're in that catch-22 situation of fighting fires every day. Maybe someone from SARS can help.
I think you need to apply in terms of section 164 because you're fighting this assess. Have you applied? You already know, but then they can't hold it. But now they're going to say we want security. Oh, ouch. Yes. No, I feel your pain. This is really not a healthy situation. Shannon, it seems that, well, let's see. Let's just ask, I'm going to get to you now, just ask, it's like, have they ever been held personally liable for somebody else's debt? Have they been convicted of a tax offence? Have they frequently failed to pay? Are they frequently incurring non-compliance penalties? Are they under the management of some crook? Then you can say to SARS, well, look, none of the above. So then SARS doesn't have the right to ask. So I think you can tell SARS, you don't have the right to ask because we don't fall into one of these categories. Sorry, was there another? Yes.
I think the section that she's referring to is not the one, it's not 161. It's essentially the problem regarding certain VAT audits or other audits on refunds, which may be protracted, and then there's a right that the taxpayer or VAT vendor has to tender appropriate security, which of course will not necessarily be cash because the whole issue revolves around cash. So adequate security in any other form, and then we will release the refund. Well, it's mandatory, even though the refund audit is not finalized. So there's a risk to SARS. We haven't finalized the audit, but we're prepared to pay the refund in the interim because of cash flow problems.
Provided you have security.
Well, provided you tender security, but it doesn't have to be cash because of...
Could be a surety.
Cash is the problem here.
Bank guarantee.
So that's under the refund section. You'll find that provision. So that's what probably happened there.
Thank you. So
otherwise, you'll have to wait till the audit is completed, and then obviously we don't have time periods or time restrictions on that, unfortunately. Okay, under 161, I think you raise a valid argument that the law doesn't necessarily give effect to the original intent, which was essentially to work prospectively. So if you want to continue as a VAT trader and impose and charge VAT and collect VAT, etc., or a withholding agent in future, or collector of pay as you earn, but you have this history of not paying this, to allow you to continue in that trade and gather, well, essentially withholding taxes due to SARS, we want some sort of security in case you default again. That was the rationale under 161. Not we anticipate some good profit next year and we want upfront cash. So I think we should relook this because it comes from VAT, but the idea was also to apply it to like withholding taxes. Before we trust you again to collect and withhold taxes, because of your previous non-compliance, we want some sort of security. That was the intent, but it's not always necessarily what comes out.
So there's like what did they say? Camel is a horse designed by a committee. So there was one person had intention, and then this came out. The National Treasury. Thanks. Okay. Now here's still have the will to live. Just checking your pulse. You can tell me to stop anytime. Right. Okay. Lost the will to live. Okay. Well, I mean, I'm amenable to that. Let's see. Okay, well, in that case, I give a vote to dealing with one of the following three: the preservation order, or the civil judgment, which is interesting and short, so a lot of people might vote for that, or compulsory repatriation of foreign assets, which would only entertain you if you have foreign assets. So, who would go for preservation order? Nobody. Well, okay, that's a good thing I didn't talk about it. You obviously wouldn't find that very interesting. Civil judgments, the short one. Right, okay. And the compulsory repatriation of foreign assets? I'm sorry, we're going for the short one, Charmaine. That is generally, this is a democracy. Civil judgment. SARS has always had the right to go and file a little notice at the clerk of the court to say, this person owes me X amount of money, and that thing would have the effect of a judgment. In fact, numerous letters from SARS go out every day from the collections department to say, we will take judgment against you without further notice if you don't pay. And then they generally don't, but they can. And by the time that they do, people are generally upset to find out that they can't borrow money from the bank because they've got a judgment against them. But SARS has always had this right. Now, the nice thing now is that, one, SARS must give you 10 business days notice. We are going to take judgment against you, so you have time to prepare, and knowing that judgment is going to be taken against you by the filing of a simple document at the magistrate's court that's going to be stamped. That's how easy it is for SARS. If you have notice, maybe you can try and negotiate with them if you really don't need a judgment against you, but that's about it. Interestingly, you can also now do this despite the fact that there's an objection or appeal. SARS can do this unless you applied for the suspension. So if you are objecting to an assessment, you must always try to apply in terms of 164 for the suspension, because it specifically says that SARS cannot then just take a judgment against you willy-nilly. Well, it's not willy-nilly, it's in terms of procedure, but the effect is that it's willy-nilly. And then the interesting thing is, if SARS or a senior SARS official is of the view that this would prejudice the collection of tax, which is very broad, I mean, that could be anything. What is the prejudice of the collection of tax? They don't have to give you notice. I don't see how that's going to work, because if SARS gives notice, they're going to wait 10 days before they take a judgment. But then once they've taken a judgment, then they're going to apply to get the sheriff, and then the sheriff is going to go for the movable assets. I mean, if that happens 10 days earlier or later, how's that really going to prejudice them? Because SARS's history of sending out the sheriff after they've taken judgment against you is not good. They take judgment and then just magically expect the money to come in. What they need is a warrant of execution. That does not mean they can kill you. They can execute against your assets. Okay. So that's what I had to say. I'm sorry you've lost the will to live. I apologize. I did warn you. Last question? No? Good. Okay. Thank you.